Rights Bureau presentation on discrimination in the hospitality industry. First, we will briefly explore the Human Rights Bureau and the administrative process. The Montana Human Rights Bureau is organized under the Montana Department of Labor and Industry and is part of the Employment Relations Division. The Human Rights Bureau is the state agency charged with enforcement of the Montana Human Rights Act and the Governmental Code of Fair Practices. Through a contract with the federal government, the Equal Employment Opportunity Commission, or EEOC, the Bureau also processes employment discrimination claims filed under Title VII of the Civil Rights Act of 1964, the Americans with Disabilities Act, and the Age Discrimination in Employment Act. The Bureau is the first step in a multi-level administrative process that handles complaints of discrimination. Someone who is considering suing for discrimination must exhaust the administrative process before a court will hear their case. The Bureau is a neutral entity. It does not represent charging parties, nor does it defend respondents. The Bureau's fidelity is to the law it is charged to enforce. The Bureau's main function is to conduct independent and neutral investigations into complaints of discrimination. It is important to understand that the Bureau does not get to turn away a complaint that is filed. We are obligated by statute to conduct an investigation. Complaints come to our Bureau in three ways. The first way is through the Bureau's intake process, which is an hour-long telephone appointment with an investigator to discuss whether or not a caller's situation falls within the laws enforced by the Bureau. The second way is through self-drafted complaints, and the third is attorney-drafted complaints. The Bureau also provides mediation services, which are voluntary and confidential and completely free. Lastly, the Bureau offers education to the public, including employers, employees, students, tenants, housing providers, and other interested parties throughout the state. The Bureau does this as a preventative effort to further awareness of non-discrimination laws. Here you see the bottom half of a flow chart the Bureau uses to help the parties understand the life of a complaint and the administrative process. At this stage, a complaint has been investigated and there has been either a finding of reasonable cause or no reasonable cause to believe discrimination occurred. If the Bureau determines there is no reasonable cause, the charging party can either go directly to district court and file a suit, or he or she can object to the Bureau's decision to the Human Rights Commission. The Human Rights Commission is comprised of 5 commissioners appointed by the Governor of Montana. If the Commission affirms the Bureau's no-cause finding, the charging party can file in district court. If the Commission sustains the charging party's objection, the case will go to the Office of Administrative Hearings for a contested case proceeding. If the Bureau determines there is reasonable cause to believe discrimination occurred after investigating a case, the case will then go into a period of conciliation, which is a chance for the parties to reach a voluntary settlement. If the parties settle, the case stops there and is closed. If the parties cannot reach a settlement, then the case goes to the Office of Administrative Hearings for a contested case proceeding. If the case is sent to the Office of Administrative Hearings for a hearing, either by the Commission sustaining an objection or by the Bureau finding cause, either side can appeal the Office of Administrative Hearings hearing officer decision to the Commission. The Commission is the final level of the administrative process for complaints of unlawful discrimination for the state. The Commission's role is to sit in independent judgment of the work of the Human Rights Bureau and Hearings Bureau by conducting quarterly hearings on objections and appeals. Next, we will review the basics of the discrimination laws enforced by the Bureau, including retaliation. In order to understand what discrimination is, we must first define it. Unlawful discrimination can be simply defined as an adverse action taken in a protected area against an individual because of his or her protected class status. In order to understand the definition of discrimination, we must break down and define some of its terms. This slide shows a list of the protected areas under anti-discrimination laws that the Bureau enforces. The protected areas include employment, public accommodations, governmental services, housing, education, insurance, and financial transactions. Here you see all the protected classes under federal and state laws. Montana's protected classes are the same and overlap with the federal protected classes. But note that Montana law recognizes the additional protected classes of creed, marital and familial status, and political belief, whereas federal law does not. Also note that the protected class of political belief is only applicable in the areas of governmental services and government employment, and familial status only applies to housing discrimination. Now let's walk through these protected classes to give you a clearer understanding. First up is age. Under federal law, someone belongs to the protected class of age if they are 40 years old or older. In Montana, an individual belongs to this protected class at any age. Age does not mean level of maturity or ability to handle responsibility. Discrimination complaints based on the protected class of sex can assert that an individual was treated less favorably because of their biological sex or because they do not conform with the stereotypes of their sex. There are a variety of subcategories under sex as well, including pregnancy, sexual orientation, and gender identity. A lot of our sex-based complaints filed at the Bureau allege sexual harassment, which can include harassment from people of the same sex as the charging party. Title VII of the Civil Rights Act, the federal law that prohibits race discrimination, does not contain a definition of race. Race discrimination includes discrimination on the basis of ancestry or physical or cultural characteristics associated with a certain race, such as skin color, hair texture or styles, or certain facial features. For coding purposes and reporting, race includes white or Caucasian, Black or African American, Native Hawaiian or Pacific Islander, American Indian or Alaska Native, bi or multiracial, and Asian. The protected class of color not only refers to white and black comparisons, but also extends to discrimination based on shades of skin color. For example, there have been cases where an African American with a darker skin color has felt harassed by other African Americans who are lighter skinned simply because of their darker skin color. Most of us have a general understanding of religion. A Christian, Muslim, Jew, or Mormon, just to name a few, can fall under the protected class of religion. However, this protected class also includes the absence of religion, meaning that a person can file because he or she was not the preferred religion. Also, in the area of employment, a person can ask for religious accommodations, such as time off to attend a powwow or to observe their religion's Sabbath. Creed is similar to religion. It is a deeply held belief, but according to the legislative history of the Montana Human Rights Act, it is broader. Things that fit within the protected class of creed include vegetarianism, white supremacy, or the belief that one should not be vaccinated. Disability is very broadly defined as a physical or mental impairment that substantially limits a major life activity. If someone characterizes or perceives another to be a person with a disability, or that person has a record of a disability, the person would fall under this protected class as well. National origin is defined as ancestry according to the Montana Code. Some examples include Arab, Afghani or Middle Easterner, East Indian, Hispanic, and Mexican. The protected class of marital status protects people from discrimination based on their marital status and who they are married to. An example includes a couple that worked together and once they got married were told that one of them had to leave. Another example is a school district who discharged a bus driver because her husband was convicted of running a meth operation. Both of these cases were marital status cases. In the area of governmental services and employment, the government cannot discriminate against someone based on their publicly held, publicly shared belief. Political belief or ideas is much broader than just your party affiliations. It includes your stance on issues of public concern that you hold out to the public. As an example, the Bureau had a case in which an individual felt she was passed over for a position in local government because she stated she had attended city council meetings and publicly advocated for government transparency. Her public vocalization in support of government transparency placed her in the protected class of political belief. But as mentioned, this protected class only applies to government employment, governmental services, licensing, and public contracts, things that are underneath government authority. The protected class of familial status applies only in housing cases. The Montana Code Annotated defines it as having a child or children who live or will live with a person. For example, a landlord cannot rent to only people with children above the age of 5. Retaliation has been for some time and continues to be the second highest filing the Bureau receives each year. Retaliation is statutorily defined and is different than the dictionary definition of the word. A lot of people are confused by this, and the Bureau fields a couple of calls each week where someone complains about retaliation, but what they really experienced doesn't fall under the statutes we enforce. The Merriam-Webster definition of retaliate or retaliation is to return like for like or get revenge. However, the definition under the state and federal anti-discrimination laws is much more specific regarding the reason or motivation behind the revenge taken. The Bureau only has the authority to investigate complaints of retaliation that allege that a respondent took a significant adverse act against a charging party because that person engaged in protected activity. When considering whether or not an employer's action is a significant adverse act, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. So to understand the legal definition of retaliation analyzed by the Bureau, you must also understand what protected activity is. Protected activity includes opposition to discrimination, participation, and requests for accommodations. We will now look a little closer at each protected activity. There are 3 things to understand regarding opposing discrimination as a protected activity. Opposition puts an employer on notice, it is done in good faith, and it is done reasonably. Opposition can be protected even if it's informal. A person doesn't have to use magic words like harassment or discrimination. At the Bureau, we look at it from the perspective of whether a charging party said something to the respondent that put the respondent on notice that the charging party was concerned about something that would fall within the Bureau's purview. Said another way, is the charging party voicing a concern that the Bureau might be interested in? However, the protection for opposition is limited to those who act with a reasonable good faith belief that the conduct opposed is unlawful or could become unlawful if repeated. For example, what if a woman complains to her boss that she doesn't like that her coworker asked her out on a date? Well, this one act may not legally qualify as sexual harassment, but the coworker could possibly continue on a path that would become harassing if left unchecked. Therefore, the woman's complaint of an incident that could manifest as sexual harassment would be protected activity. Also, if the manner of opposition is unreasonable, the charging party will likely give the respondent a legitimate non-retaliatory reason to take an adverse action against them. For example, an employee who yells at his boss in front of coworkers, a list of complaints that also include an allegation of racism, will likely face consequences for insubordination. The unreasonable manner with which the employee reacted will give his boss a legitimate, non-retaliatory reason to discipline him. The Bureau recognizes that a charging party may not prevail on a complaint if it was brought in bad faith or if the manner of opposition was not reasonable. So we have covered opposition as a protected activity, and we'll now go over participation as a protected activity. Respondents cannot punish a person for filing a complaint, serving as a witness, or participating in any other way in an investigation matter, even if the underlying discrimination allegation is unsuccessful or untimely. This has been interpreted to include participation in an employer's internal complaint process, even if a charge of discrimination has not yet been filed. The third and last type of protected activity we need to discuss is requests for accommodation. Requesting an accommodation for either a disability or religion is a protected activity as well. An example of a request for religious accommodation can be a Native American employee asking for time off to attend a powwow. A request for an accommodation for disability in its simplest terms is when a charging party requests a modification or change due to a mental or physical health condition. An example of this in the area of employment is an employee requesting time off to seek out cancer treatments. An example of this in the area of public accommodation is a shopper asking a store for a modification to the COVID-19 mask policy because of a disability. So now that we've gone over what protected activity is, let's review again what retaliation is. It's an adverse action taken against someone because they're engaged in a protected activity. So unlike discrimination, the person does not have to be a member of a protected class to be retaliated against, so long as they engaged in a protected activity. But retaliation provisions are part of the Montana Human Rights Act, the Governmental Code of Fair Practices, and federal anti-discrimination laws, so the Bureau investigates complaints of discrimination and retaliation. So now that you know about the basics of discrimination and retaliation, let's go over what you need to know about discrimination as a public accommodation in Montana. The Montana Human Rights Act defines a public accommodation very broadly as a business establishment or place that caters or offers its services, goods, or facilities to the general public. The statute sets out many examples of places that classify as public accommodations, but notes that the list is not exhaustive. Some of the examples included in the statute are restaurants, hotels, trailer parks and campgrounds, bathrooms, and hospitals. While the definition of public accommodation is broad, the statute does carve out one exception: institutions or clubs that are distinctly private, including lodges of a recognized national fraternal organization. However, an institution will not be considered distinctly private, and therefore not part of the exception, if it has more than 100 members, provides regular meal service, and regularly receives payments for dues, fees, or the use of space or services by non-members. The Montana Human Rights Act states that it is unlawful discrimination for an owner, lessee, manager, agent, or employee of a public accommodation to refuse or deny a person the services, goods, facilities, advantages, or privileges of a public accommodation based on a protected class. It is also unlawful discrimination for the public accommodation to publish, circulate, issue, display, post, or mail a written or printed communication, notice, or advertisement that states or implies that any of the services, goods, facilities, advantages, or privileges of a public accommodation will be refused or denied based on a protected class. These are the protected classes under the area of public accommodation. They include age, at any age, sex, which includes pregnancy, gender identity, and sexual orientation, race, color, religion, creed, mental or physical disability, national origin, and marital status. There are other protected classes under different protected areas in anti-discrimination laws. However, please note that these are the only applicable protected classes under Montana law in the area of public accommodations. Discrimination in Montana's public accommodations can take several different forms. They include disparate treatment, or treating someone differently than everyone else because of their protected class, denial of service, printed notice implying or stating that service is denied based on a protected class, harassment by association with someone in a protected class, failure to accommodate, and in an indirect way, retaliation for opposing a discriminatory act or requesting an accommodation. We will now review these types of discrimination in public accommodations more closely. Disparate treatment cases allege that a respondent treated a charging party differently than others based on his or her protected class. The first step of a disparate treatment case is the prima facie case. Prima facie is a Latin term that means on its first appearance. The charging party must prove each element of a prima facie case to show that what respondent did, the adverse act, looks like discrimination on its first appearance. The first element requires the charging party prove that he or she falls under a protected class. Next, the charging party must show that he or she was subjected to some type of bad act by the respondent. And lastly, the charging party must prove that circumstances raise a reasonable inference that he or she was subjected to the bad act because of his or her membership in the protected class. Some evidence that raises a reasonable inference include that the adverse act does not happen to those who are not members of the protected class, or comments that suggest a protected class was a factor in the act. When analyzing disparate treatment cases, a shifting burden analysis is used. As we just covered, in the first step of analysis, a charging party has the burden of proving the elements of a prima facie case. After the charging party meets that burden, the burden then shifts to the respondent to produce a legitimate, non-discriminatory reason for the adverse act it took against the charging party. Once the respondent produces that legitimate non-discriminatory reason, the burden then shifts back to the charging party to prove that the reason proffered by respondent is pretext or unworthy of belief. In order to prevail on a disparate treatment complaint, a charging party must prove his or her case by a preponderance of the evidence. This means that discrimination more likely than not occurred. This standard is less onerous than beyond a reasonable doubt or based on clear and convincing evidence. Rather, it is a 51% probability based on the evidence at hand that discrimination occurred. It is important to note that the administrative rules of Montana change this analysis a bit in the event that there is direct evidence of discrimination. When there is direct evidence, there is no shifting burden. Instead, the respondent must prove by a preponderance of the evidence that an unlawful motive played no role in the action it took against charging party. In the alternative, the respondent can prove that the direct evidence is not credible and unworthy of belief. Direct evidence speaks directly to the issue, establishing that discrimination occurred without support from other evidence or presumptions. An example of direct evidence would be a sign posted in a convenience or liquor store that tribal IDs are not accepted for making purchases of alcohol and tobacco. Another example of direct evidence would be a hotel manager stating to someone wanting to rent a room that they cannot stay there because of his or her disability. Now let's walk through a case example to show the shifting burden in action. A charging party filed a disparate treatment case with the Bureau against a hotel she had stayed in for several months. Walking through the elements of the prima facie case, charging party experiences a visual impairment qualifying her as a member of the protected class of disability. This satisfies the first element of the prima facie case. Charging party asserts that despite her request, her room was not cleaned in the same manner as other guests at the hotel, satisfying the second element, that she was subjected to an adverse act. When charging party complained that her room was not being cleaned, staff told her that her room was cleaned, but she couldn't see it. This comment tends to raise a reasonable inference that if charging party's room was not being cleaned as she asserted, that staff knew she had a visual impairment and believed she would not be able to see whether or not the room was clean. This satisfies the third and final element of the prima facie case. When the burden shifted to respondent, it proffered that they have room cleaning policies and that they followed those policies, cleaning charging party's room when required. Then it was up to charging party to show those reasons were not worthy of belief. Charging party had witnesses that stated they observed the state of her room after it was allegedly cleaned by respondent and that it was not cleaned. Respondent acknowledged giving charging party cleaners to clean her room herself, and one of charging party's witnesses stated that she used the cleaners to clean the room because of the inadequate job staff had done that day. Records obtained during the Bureau's investigation showed that cleaning logs did not specifically show that charging party's room had been cleaned on any particular day, while it showed that surrounding rooms had been. With this evidence, charging party was able to overcome respondent's assertions that it cleaned her room in the same manner as other rooms and that she was being treated differently based on her visual impairment. Another type of public accommodations case is when someone is denied services or goods based on membership in a protected class. In order to establish a prima facie case, the charging party must prove that he or she is a member of a protected class, he or she sought to enjoy the services, goods, facilities, advantages, or privileges of respondent's public accommodation, and finally, that he or she was refused the services, goods, facilities, advantages, or privileges of the public accommodation under circumstances giving rise to an inference of discrimination. Like disparate treatment cases, denial of service cases employ a shifting burden analysis. So after a charging party satisfies the three elements here, the respondent must produce a legitimate, non-discriminatory reason for refusing to serve charging party. It then becomes charging party's burden to prove why respondent's reasons are pretext or unworthy of belief. The Bureau received a complaint recently asserting denial of service based on disability. In the complaint, charging party asserted her gym membership was canceled after she explained to another member that she has severe allergic reactions to fragrance during a group class, which then prompted the member to get up and move to the other side of the room. Respondent stated that her membership was canceled because they received multiple complaints about her, and the member who moved away from her during class canceled their membership after interacting with her. So in essence, her membership was canceled for the way she was treating their customers and impacting business, not because of her disability. In this case, charging party was not able to show respondent's reasons were pretext or unworthy of belief, and it was a no-cause case. The Bureau has recently seen a number of complaints filed by Native Americans against hotels asserting they were denied services based on race. A couple complaints include allegations that hotel staff denied rooms to residents of the Blackfeet Indian Reservation because they were supposed to be under lockdown due to the COVID-19 pandemic. Another type of public accommodation case we see at the Bureau is where a public accommodation has some type of printed notice that either states or implies that it will refuse service based on a protected class. Of course, such notice or advertisement is prohibited in and of itself by statute, but also such notice can be used as direct evidence of discrimination in the analysis of a case. A Native American man was a regular customer at a convenience store in Billings that had a sign near the cash register stating that it would not accept certain forms of ID for the purchase of alcohol or tobacco. The list of unacceptable IDs included broken or taped ID, expired ID, paper copies, out-of-state ID, tribal ID, and military ID. When the man entered the store in 2016 to buy a small bottle of champagne, he offered his tribal ID to the cashier. He was told tribal IDs were not accepted, and the cashier asked for a Montana driver's license. The Bureau found the posted sign at the convenience store was direct evidence to establish discrimination. Remember that with direct evidence, it then becomes the respondent's burden to prove that an unlawful motive played no role in the challenged conduct. A 2007 Montana law prescribed that tribal IDs must be treated the same as Montana's driver's license. Therefore, the convenience store was unable to show that it had a legitimate reason for refusing tribal ID or that a discriminatory motive played no role. This case went on to the Office of Administrative Hearings, which awarded the man $7,000 in emotional distress damages that he experienced due to the illegal discrimination at the convenience store. The hearings officer agreed with the Bureau that the sign was direct evidence of discrimination, but it also stated that a posted sign announcing that a convenience store would not accept tribal IDs was a statement that it would deny the holder of a tribal ID, who is necessarily a member of that tribe, sales of controlled substances based upon the presentation of that tribal ID in violation of the law. When someone is not denied services at a public accommodation, but they are treated so poorly based on their protected class while receiving services, such treatment would be considered harassment in the area of public accommodation. In order to establish a prima facie case, the charging party must prove that he or she is a member of a protected class, he or she sought to enjoy the services, goods, facilities, advantages, or privileges of the respondent's public accommodation, and finally, he or she was allowed to use the services, goods, facilities, advantages, or privileges of the public accommodation, but was subjected to markedly hostile conduct that a reasonable person would find objectively unreasonable under circumstances giving rise to an inference of discrimination. Like disparate treatment cases, harassment cases in the area of public accommodation employ a shifting burden analysis. So after a charging party satisfies the three elements seen here, the respondent must produce a legitimate, non-discriminatory reason for the challenged conduct. It then becomes charging party's burden to prove why respondent's reasons are pretext or unworthy of belief. A few years ago, a truck driver broke down and had his rig towed to a repair shop in Montana. The truck driver was from Iraq and an adherent to the Islamic faith. During the course of servicing the rig, the truck driver and shop owner's interactions became contentious. The truck driver recorded a video of a portion of their interaction, which showed the shop owner cursing the truck driver, Iraq, and Islam, and telling the truck driver to go back home where he came from. We don't need you here. This video constituted direct evidence of discrimination, which of course then means the shop owner had to either prove the evidence was unworthy of belief or that there was no discriminatory motive to his conduct. The shop owner proffered that the truck driver instigated the conversation, in part, by threatening that Muslims would take over America, and therefore the shop owner was only responding in defense in the video clip. The Bureau found that there was no evidence to suggest that the shop owner's conduct was defensive, but instead the shop owner harassed the truck driver during its provision of services based on his national origin and religion. Physical touching can also be considered markedly hostile conduct. The Bureau recently had a complaint filed against a large retailer wherein the charging party alleged that an employee who was supposed to be helping her find a product at the store began rubbing up against her in a sexual manner. This was a complaint of harassment in the area of public accommodation as well. It is interesting to note that someone can also file a discrimination complaint if they are treated differently, denied services, or harassed because of their association with a person who is a member of a protected class. This type of complaint is called a by association complaint. An example would be a restaurant refusing service to a white woman because she is married to a black man. Another type of discrimination case seen in the area of public accommodations are failure to provide reasonable accommodations for a disability. The basic elements are that the charging party is a person with a disability who requests an accommodation and the respondent failed to provide an effective accommodation for the disability. If a charging party can establish a failure to accommodate claim, the respondent may be able to put forth the defense of undue hardship. An undue hardship can be in terms of difficulty in implementing the accommodation or the expense associated with implementing the accommodation. Also, a respondent is not required to provide an accommodation that would fundamentally alter its business. An example of a public accommodation failing to provide a reasonable accommodation for disability would be a patient at a hospital with a hearing impairment needing a sign language interpreter as an accommodation. The Bureau also had a case in which a visually impaired woman tried to join a local gym and requested an accommodation for her disability. She asked that a sticker that she could fill with her fingertips be placed on the appropriate buttons on a treadmill that she used so that she would know which buttons to push. The gym denied the accommodation without further discussion or consideration of how putting a sticker on a treadmill would be an undue burden. The Bureau found that the gym failed to provide an accommodation or articulate a valid defense. Another type of failure to accommodate complaint seen at the Bureau in the area of public accommodation involves service animals. A service animal is defined as a dog or miniature horse that is individually trained to provide assistance to an individual with a disability. Emotional support animals are not included in this statutory definition. In one service animal case, a patron at a bar was told his dog was not allowed upon entering. When the patron explained the dog as a service animal, the bartender retorted that his dog was not wearing a vest. The bartender acknowledged during the Bureau's investigation that he had told other patrons to leave if they didn't have papers or a vest for a service animal that entered the bar. The patron in this case was pretty smart in getting the bartender to write down on paper that he was being denied service because he had no proof of his dog's status as a service animal prior to leaving the establishment. After an investigation, this was a cause finding because public accommodations cannot require documentation or certificates that prove an animal is a service animal. It should also be noted that a public accommodation cannot ask that the animal physically demonstrate what it does for the person with a disability. It is also important to understand that in addition to failing to accommodate a service animal, a public accommodation can violate the law in the way it asks questions about service animals entering the premises as well. A few years back, a restaurant told a man seeking service that he needed a vest and paperwork for his service animal to be permitted inside the establishment. The manager made the remark that if the man had a real service dog, he would know the laws. The man then became aggressive and belligerent, using foul language. Ultimately, the man was asked to leave not because of his service animal, but because of his behavior. The Bureau found cause and the matter went to the Office of Administrative Hearings for a hearing. The hearing officer acknowledged that the manager made a good faith mistake in her understanding of the law and what questions she could ask, while also acknowledging that the manager's mistake exacerbated the confrontation that ensued. However, the hearing officer also stated that neither the manager's questions nor the man's disability warranted his boorish behavior. Therefore, partly owing to the man's own behavior and part in the incident, the hearings officer awarded the man only $2,500 in damages for emotional distress for the manager's violation of the law. So remember, public accommodations cannot require documentation proving the status of a service animal, and they are only allowed to ask two questions: whether the service animal is required because of a disability, and to describe the service the animal has been trained to perform. But be cautious, because although public accommodations can ask these two questions regarding service animals, when it's not obvious that the person is disabled or obvious what task the animal performs, it cannot inquire about a person's disability. Also remember that the definition of disability includes mental impairments, so you may not always be able to tell if someone experiences a disability or what kind of task a service animal could perform for someone. Of course, that is the type of situation where it is okay to ask these two permissible questions. There are some additional points about service animals in public accommodations that you should know. According to the Montana Human Rights Act, a person with a disability has the right to be accompanied by a service animal in all public accommodations without being charged extra for the service animal. However, a person with a service animal, whether fully trained or in training, has the responsibility of paying for any damage the service animal may cause. Additionally, a person without a disability is afforded these same rights and responsibilities if he or she is training a service animal. However, by statute, a service animal in training must wear a leash, collar, cape, harness, backpack, or some type of writing that identifies that the animal is a service animal in training, and the identification must be visible and legible from at least 20 feet away. There were some changes to the Montana Human Rights Act in 2019 regarding service animals. The Bureau has not yet had a case requiring a determination about how these changes may affect the portions of the statute enforced by the Bureau, but some of the changes are noted here on this slide. A person may be asked to remove a service animal if it is not housebroken or if the animal is not under control and the person has not taken effective action to control the animal. However, in this type of circumstance, the person must be given an opportunity to stay and receive goods and services without the animal's presence. If a public accommodation posts a sign that animals are prohibited on the premises, it must also indicate on that sign that service animals are permitted. A person who misrepresents an animal as a service animal can be asked to remove the animal from the premises, and local law enforcement may be called to investigate. And finally, misrepresenting an animal as a service animal in order to access a public accommodation with the animal can be a misdemeanor under certain circumstances, where the person has previously been given a written warning regarding the fact that it's illegal to intentionally misrepresent a service animal, and the person continued to misrepresent the animal as a service animal in order to gain any of the rights or privileges afforded to a service animal. Another type of case that can come up in the area of public accommodation is retaliation. It's important to note that retaliation is its own creature, so to speak, rather than a subcategory of discrimination in the area of public accommodation. It is a bit indirectly related. Unlike most other forms of discrimination, the person being retaliated against does not have to be a member of a protected class or associated with a member of a protected class. Here you see the three elements that constitute a prima facie case of retaliation. Retaliation is when a respondent takes a significant adverse act against a person because he or she engaged in a protected activity. Protected activities include opposing or objecting to discriminatory acts, participating in an investigation or case of discrimination, and requesting an accommodation. For example, if a customer complains to a restaurant manager that they don't like that their friend was denied service because of their disability, the customer has opposed disability discrimination and engaged in a protected activity. Likewise, if the friend files a complaint against the restaurant for being denied service based on a disability, and then the customer acts as a witness in the friend's investigation, the customer has then engaged in a protected activity. And lastly, if the friend with a disability asks for a reasonable accommodation from the restaurant, such as the use of a service animal, the friend has engaged in protected activity. When determining whether or not the charging party was subjected to an adverse act, the question revolves around whether or not the act may dissuade a reasonable person from engaging in protected activity again. Continuing on with the example just discussed, if the manager of the restaurant kicks out the customer complaining of the discriminatory acts against his friend simply because he complained about the discrimination, the manager has then retaliated against the customer. It is reasonable to think that being kicked out of a restaurant could dissuade the customer from speaking out again against discrimination. The last element requires a charging party to prove that the adverse act was taken in response to the charging party engaging in a protected activity. If the charging party is successful in proving all three elements, he or she has established a prima facie case of retaliation. Just like under the disparate treatment analysis we reviewed earlier, when a charging party establishes a prima facie case of retaliation, a shifting burden analysis is used, requiring the respondent to provide a legitimate, non-retaliatory reason for the adverse act. The burden then shifts to the charging party to ultimately prove that the non-retaliatory reason proffered by the respondent is pretext or unworthy of belief in order to prevail on a claim of retaliation. Now we have concluded going over the various types of complaints in the area of public accommodations. One last thing to be aware of is that there is a statutory exception carved out of the public accommodations statute for treating people differently based on their age. Public accommodations are permitted to give special benefits, incentives, discounts, and/or promotions based on age. And of course, examples of that are early bird or senior discounts that you can get at a restaurant. I've also heard of grocery stores that give a percentage discount or double coupons to customers over a certain age on certain days. And this type of disparate treatment is A-OK under the Montana Human Rights Act. Now let's discuss what you need to know about discrimination as an employer in Montana. There are various types of discrimination that can occur in the area of employment. They include disparate treatment, harassment, by association, failure to accommodate, and retaliation. As a business operating in the hospitality or service industry, the two major problem areas to keep in mind are harassment and failure to accommodate. Now we're going to turn our focus on harassment, also known as hostile work environment. Based on the definition of unlawful discrimination, you may be asking, where does harassment fit in? To explain that, let's first define harassment. Harassment can be any behavior that slanders or shows hostility toward another person because of their differences. Harassment creates an offensive, intimidating work environment and/or negatively affects a person's work performance or employment opportunities. However, it is important to note that not all harassment is unlawful harassment. Unlawful harassment is a subset within harassment. Unlawful harassment is unwelcome conduct that targets someone based on protected class status that is sufficiently severe and/or pervasive that it alters the work environment. When the Bureau investigates a complaint of harassment in the area of employment or hostile work environment, which is where the acronym HWE comes from, there are a number of laws that apply. Under all circumstances, the Bureau relies on the Montana Human Rights Act, which prohibits harassment based on any protected class regardless of the number of individuals employed by an employer. If the employer is a governmental entity, the Governmental Code of Fair Practices also applies. If the charging party asserts he or she was harassed in the workplace based on being a person with a disability, the ADA applies so long as the employer has at least 15 employees. If the charging party asserts he or she was harassed in the workplace based on being age 40 years old or older, the ADEA applies so long as the employer has at least 20 employees. If the charging party asserts he or she was harassed in the workplace based on being a member of any other protected class, Title VII of the Civil Rights Act of 1964 applies, so long as the employer has at least 15 employees. Who can harass an employee? What type of actors can be involved in a complaint of harassment in the workplace that may subject an employer to liability? The most common harassment complaints filed at the Bureau allege a coworker or a supervisor harassed a charging party based on his or her protected class. However, it's also important for employers to understand that they are responsible for controlling their employees' work environment, which means that they can be held liable for harassment perpetrated by non-employees as well, such as contractors, agents, customers, and even delivery truck drivers. There can also be employees who are not directly targeted for harassment by anyone, but are collateral targets. If an employer has 2 employees who willingly engage in inappropriate behavior and a coworker is present and subjected to the offensive banter, that person could be a collateral target. The Bureau recently had a case filed by an employee in a healthcare office. Although conduct was not directed towards the employee, she was subjected to what she called a frat house environment where coworkers and supervisors made sexual comments and noises, played sexually explicit videos in the workplace, and discussed genitalia and orgies. This employee was a collateral target of sex-based harassment. These 5 elements constitute the analysis of a harassment complaint. 1. Charging party is a member of a protected class. 2. Charging party was subjected to offensive conduct based on his or her membership in a protected class. 3. The offensive conduct was unwelcome. 4. The offensive conduct was so severe or pervasive that it altered the conditions of employment and created an abusive working environment. And lastly, 5. A basis for holding the respondent liable. The first 4 elements establish that harassment occurred in the workplace, while the 5th element looks into whether or not the employer can be held responsible for the harassment. After a charging party shows that he or she belongs to a protected class, they then must prove that they were subjected to offensive conduct based on that protected class. Offensive conduct can be verbal or physical in nature and include slurs or name-calling, jokes, innuendo, or comments, pictures, lyrics and music, blocking another's movement, pushing, and intimate touching. Whether or not the conduct would be considered offensive is judged by whether or not a reasonable person would objectively find the conduct offensive. The third element requires that the offensive conduct be unwelcome by the charging party. While the review of whether the conduct is offensive is more of an objective standard, unwelcomeness is reviewed as a more subjective standard. The question of whether the conduct was unwelcome revolves around whether the employee regarded the conduct as undesirable or offensive and did not solicit or incite it. Some examples that indicate an employee found offensive conduct unwelcome include telling the person engaged in the conduct to stop or that they do not like the conduct, making a complaint to their employer, or filing a complaint with the Bureau. An employee's nonverbal cues can also express unwelcomeness, such as leaving the room where the conduct is taking place, turning away from the conduct, or even shaking of the head in disapproval of the conduct. On the other hand, if the charging party participates and engages in the conduct, that tends to show that the conduct was not unwelcome. In order to prove a harassment claim, the charging party must also show that the offensive conduct was sufficiently severe or pervasive as to create a hostile or abusive work environment. While the charging party's perspective is taken into account, making a determination on this element is based on a reasonable person standard. It is important to note that the conduct must be either severe or pervasive, but not both. Severity relates to quality, while pervasiveness relates to quantity. Who the bad actor is impacts severity as well. Offensive conduct from a supervisor can be more impactful on an employee than just a coworker or peer. Physical touching or an unambiguous racial slur are common examples of severe offensive conduct. For example, a coworker who flicks his female coworker's breast would be severe, as would a supervisor calling his subordinate the N-word. Conduct that is not severe can still create a hostile or abusive environment if it occurs often enough to demonstrate a pervasiveness in the workplace. Minor isolated incidents, unfair treatment, offhanded comments, and disagreements are not unlawful harassment in the workplace. Federal and state anti-harassment laws are not meant to be a civility code. In order for a charging party to prevail on a complaint of harassment against his or her employer, there must be a basis for holding the employer liable for the harassment. If the harasser or actor perpetrating the offensive conduct is a coworker or a non-employee, then there are two steps or questions to determining whether or not the employer is liable for the coworker or non-employee's harassment toward the charging party. The first step is determining whether or not the employer either knew or should have known about the harassment. For example, the Bureau had a case where a coworker yelled out a sexually derogatory name in the workplace whenever the charging party entered the room. The coworker did so at least once, if not more, in front of their supervisor. Because the supervisor knew this sex-based harassment was occurring and was obviously part of management, the employer knew or should have known that the harassment was taking place, even prior to the charging party coming forward with a complaint once that coworker physically touched her. If it is determined that the employer knew or should have known about the harassment, then the next question is whether or not the employer took immediate and appropriate corrective action to put a stop to the harassment. In the example just given, the supervisor did nothing to stop the coworker from calling the charging party inappropriate sex-based names, nor did the supervisor report the conduct to his superiors. His position as supervisor imputed that knowledge about the harassment to the employer. His inaction also meant that the employer took no steps to stop the harassing behavior against the charging party. Therefore, employer was held liable for the coworker's harassment towards charging party. The immediate and appropriate corrective action an employer takes must be calculated to stop the harassing behavior. If the harassing conduct continues, the employer must take progressive steps against the actor that are again calculated to stop the harassment. Many times, an employee being harassed wants the harasser immediately fired. However, whether or not an employer took immediate and appropriate corrective action against a harasser is evaluated on a case-by-case basis. For non-employees, an employer with knowledge of harassment is required to take immediate and appropriate corrective action within its control. For example, if a waitress reports to her manager that a customer patted her on the behind, or the manager saw it happen, and the manager does nothing, the employer could be liable for the customer's behavior. The corrective action could be as simple as telling the customer the behavior is not tolerated in the restaurant, or if it is a more serious situation, the customer could be asked to leave. There are a couple different considerations for determining an employer's liability if the harasser is a supervisor of the person he or she is harassing. But first, we must discuss what makes someone a supervisor. Title alone is not sufficient to determine if someone is a supervisor, and determining status should be done on a case-by-case basis. An individual qualifies as an employee supervisor if A, the individual has authority to undertake or recommend tangible employment decisions affecting the employee, or B, the individual has authority to direct the employee's daily work activities. Tangible employment decisions are decisions that significantly change an employee's employment status, such as hiring, firing, promoting, demoting, and reassigning the employee. An individual with the authority to make these types of employment changes is a supervisor, even if that individual does not have the final say on whether to enact the changes, so long as the individual's recommendation is given substantial weight by the final decision maker. However, even if an individual does not have authority to undertake or recommend tangible employment decisions, he or she may still be a supervisor if they make decisions regarding daily work assignments, even on a temporary basis. A supervisor harassing an employee outside his or her chain of command may subject the employer to liability if the employee reasonably believed that the harasser has authority over them based on the harasser's influence or an unclear chain of command. However, if that is not the case, a supervisor harassing an employee outside the chain of command is analyzed like a coworker harassment case. When someone in a supervisory capacity subjects an employee to a hostile work environment, the employer may have an affirmative defense. If an employer can prove that it discharged its duty of reasonable care and that the employee could have avoided all of the harm but unreasonably failed to do so, the employer will avoid all liability for unlawful harassment. This standard lays out that both the employer and employee have duties to take reasonable care. The employer has a duty to exercise reasonable care to prevent and respond appropriately to harassment, while the employee has a duty to exercise reasonable care to use the employer's preventive measures or complaint procedures to put a stop to the harassment and avoid harm. To successfully raise an affirmative defense, an employer must prove it took reasonable steps to prevent harassment, such as implementing appropriate policies and educating its workforce, that it took prompt steps to correct any harassment that occurred, that the harassed employee unreasonably failed to take advantage of the employer's preventative measures, and that all harm could have been prevented had the employee complained in a timely manner. If both parties exercise reasonable care, the defense will fail. While this may seem like a high hurdle to jump for a law-abiding employer to avoid liability, this standard is consistent with liability standards under anti-discrimination statutes, making employers liable for its supervisors' discriminatory acts. For example, if a supervisor fails to hire a candidate based on race, that employer is liable for the supervisor's failure to hire based on a protected class, regardless of whether or not the candidate complains to higher management or whether or not higher management knew about the supervisor's discriminatory motive. Harassment is the only type of discrimination carried out by a supervisor for which an employer can avoid liability. Now let's look at each prong of the defense to understand it a little more clearly. The first prong requires an employer to exercise reasonable care to prevent and promptly correct any harassment. This means generally in the workplace and specifically as it relates to an employee being harassed. The Supreme Court stated, quote, Title VII is designed to encourage the creation of anti-harassment policies and effective grievance mechanisms. While the court noted that this is not necessary in every instance as a matter of law, failure to do so will make it difficult for an employer to prove that it exercised reasonable care to prevent and correct harassment. None of the points seen here are requirements under the law, but they are suggestions that can help an employer prove that it exercised reasonable care to prevent and promptly correct harassment. Creating and implementing concrete policies on how to deal with harassment in the workplace is the first step. These policies should also include complaint procedures for its employees and a provision against retaliating against an employee who speaks out against harassment in the workplace. An employer should also establish what process it will take when a complaint is made, including how it will conduct an investigation into the complaint if necessary. It is advisable that an employer have at least one individual outside an employee's chain of command that is able to officially take complaints. Also keep in mind that an employer may need to take immediate action once it is aware of possible harassment in order to ensure that further harassment does not occur while it's conducting its investigation into the matter. Examples include making scheduling changes to avoid contact between the parties, transferring the alleged harasser, or placing the alleged harasser on leave with pay pending the conclusion of an investigation. An employer should be careful not to involuntarily transfer or place a complainant on leave, as that could be considered unlawful retaliation. An employer should make clear that it will undertake immediate and appropriate corrective action whenever it determines that harassment has occurred. While management should inform both parties about these measures, Montana employers must exercise good judgment regarding what information is disclosed to employees relating to disciplinary actions it takes in light of Montana's confidentiality laws. Disciplinary measures taken against an employee found to have engaged in unlawful harassment should be remedial, proportional to the seriousness of the harassment, and designed to put a stop to future harassment. An employer should keep in mind that it could be held liable if the harassment continues, as the measures taken against the harasser may be deemed ineffective in those circumstances. It is advisable for an employer to keep records of all complaints of harassment. Without such records, the employer may be unable to identify when an employee has a pattern of harassing others. If an employee has a pattern of engaging in unlawful harassment, it can assist an employer with determining credibility in a complaint or evaluating disciplinary measures needed. Periodic training of both management and employees can be an effective workforce educational tool to remind employees of the law and their responsibilities, but also such training can demonstrate that an employer takes harassment in the workplace seriously. The second prong of the defense looks at whether or not the employee unreasonably failed to take advantage of preventative or corrective opportunities provided by the employer or to avoid the harm of harassment. The employer has the burden of proving this element as well. It is not unreasonable for an employee to not report a first or second incident of minor harassment. An employee may hope that it stops, or the employee may tell the harasser to stop and give the harasser an opportunity to end the harassment before complaining to management. If the harassment continues, delay at that point could be unreasonable. However, there can be other reasonable explanations for an employee's delay to make a complaint or use the complaint procedure, such as fear of retaliation or that the complaint procedure would not be effective. In this situation, for an employer to successfully establish this second prong, it would have to prove that the employee's belief regarding potential retaliation or an ineffective process was unreasonable. This is why it is important for employers to communicate to employees that retaliation will not be tolerated and to outline the actions it will take to effectively address a complaint of harassment. Usually, an employer can satisfy the second prong of the affirmative defense if the employee unreasonably failed to utilize its complaint process. However, if the employee made other efforts to avoid harm, this element cannot be established. Other efforts to avoid harm include filing a complaint with the Bureau, the EEOC, or filing a grievance. Remember, an employer must satisfy both elements in order to successfully claim the affirmative defense and avoid liability for a supervisor's harassment. If a supervisor harassing an employee based on a protected class then takes a tangible employment action against the employee that is linked with the harassment, there is no affirmative defense available to the employer. However, in such circumstances, a disparate treatment analysis of the adverse act will be implemented. Under this type of analysis, if the employer produces evidence of a non-discriminatory reason for the tangible employment action, a determination must be made whether that explanation is a pretext designed to hide a discriminatory motive. If there is a finding that the tangible employment action is linked to the preceding harassment, the employer is liable for the entire pattern of misconduct culminating in the tangible employment action. However, if the tangible employment action was based on a non-discriminatory motive, the employer can then raise an affirmative defense to the harassing conduct. If it is determined that an action does not rise to the level of a tangible employment action, the act may still be considered along with other evidence as part of a hostile environment claim that is subject to the affirmative defense. For example, if a supervisor only threatens an employee with discipline or discharge but never carries out the threat, that will not be a tangible employment action but may be considered as part of the offensive conduct that makes up a hostile work environment claim. Harassment carried out by an alter ego of the business is automatically imputed to the employer. An alter ego is an individual who is of a certain class or high rank within the organization that he or she would be treated as the business's proxy. These include the president, the owner, a partner, or a corporate officer. If the harasser is an alter ego, the employer cannot raise the affirmative defense. So what are the consequences of a hostile work environment or harassment in the workplace? Why should we care about it? There are the obvious direct costs associated with an employer paying to defend itself against a complaint. Attorneys are not cheap. And that goes for complainants as well, since at a certain point they need to hire someone to represent them as well, and even if it's not an hourly fee, there will be likely expenses in pursuing a claim beyond the Bureau or EEOC. Then there is the all too true adage that time is money. Think about how much time will be used up in a workday for managers and employees to be deposed or testify. But there are other considerations as well. There are indirect costs to employers. Targeted employees and coworkers who see harassment occurring in the workplace are not going to be as engaged in their work. Their productivity will suffer, and the toxic work environment that is created can go well beyond just the employee who is being targeted and result in a high turnover of employees. And you better believe that if the press doesn't care about any ongoing harassment litigation, your workers will talk and spread the information, leading to a damaged reputation. But for the last several years, in the age of different movements and hashtag-dominated social media, harassment has been heavily on the radar. The best any employer can do to avoid these negative consequences is actively create a respectful and inclusive culture where all employees can focus on doing great work. Whether or not conduct is unlawful harassment can be a fine line. It can be hard to determine at what point a comment or touch can cross the line, and everyone is entitled to their own beliefs and opinions. However, behavior intended to be disparaging, mocking, or provocative based on a protected class will likely cross that line. But regardless of whether or not conduct is just in poor taste, is harassing, or is severe or pervasive enough to become unlawful harassment, understanding that certain things are off limits is just good policy in promoting a respectful and inclusive environment where all employees feel valued in the workplace. So while it may be a fine line or a gray area, it just makes sense to avoid disparaging comments or jokes about a person's sexual orientation or gender identity, a person's religious beliefs or practices, a person's political views, a person's age, a person's mental or physical abilities, a person's appearance or physical features, a person's cultural aspects or practices, or where someone is from. And while there are plenty of things that may fall into a gray area or straddle the line, there are certain words and behaviors we should all agree have no place in the work environment. It should never be acceptable to imitate a person's accent or physical disability in a mocking manner. It should never be acceptable to call someone a derogatory name based on their race or sexual orientation. It should never be acceptable to call someone retard or ask them if they took their meds. It should never be acceptable to refer to someone as a terrorist because they are of Middle Eastern descent. And it should never be acceptable to not respect someone's physical boundaries by touching them inappropriately. As reviewed earlier, while owners, managers, and supervisors have a heightened responsibility for the workplace environment, at the end of the day, as coworkers, we are all responsible for creating and participating in building a respectful and inclusive place to work. We should all take responsibility if we cross the line. No one can get it right 100% of the time, but the key is to owning up to your mistake and being accountable. This can also be the case if you're a bystander and witness inappropriate harassing conduct. Don't be afraid to speak up for a fellow coworker who's being harassed. We should all do our best to make a friendly and engaging environment. It's okay to say, "Hello there, how are you today?" And it is always right to give credit where it is due and hand out sincere compliments. If you have questions about someone's beliefs, traditions, or culture, just to name a few, or if you aren't sure whether something is offensive or not, it is okay to ask. Just make sure you engage in that conversation and ask your questions in a respectful manner. Sometimes it is easy to forget the basics we learned years ago in kindergarten. Just remember, the golden rule still applies and kindness is always acceptable. We will now turn our attention to another problem area for employers, reasonable accommodation for disability. So who is disabled? The disability discrimination laws apply to an individual who experiences a physical or mental impairment that substantially limits one or more major life activities, or a person who has a record of such an impairment, or a person who is regarded as or perceived to have such an impairment. This definition is interpreted very broadly due to the Americans with Disabilities Act Amendments Act, which expanded the definition of disability and widened the scope of protection. Congress passed the amendment in 2008 because the courts had defined disability under the ADA in such a restrictive manner that many experiencing impairments such as epilepsy, diabetes, multiple sclerosis, and bipolar disorder were unable to classify as members of the protected class of disability. Since that was not the intent of the ADA, Congress amended it to make the focus of claims be on the merits of a case rather than whether the person experiences a disability. A timely example of how to apply this definition is COVID-19. There is no bright line rule on whether or not a person who contracts COVID-19 is a person with a disability. That question has to be answered on a case-by-case basis using the definition of disability that we are going over right now. Depending on the circumstances and how the individual is experiencing COVID-19, he or she may be a person with a physical impairment that substantially limits a major life activity. However, it's also worth reiterating that the definition of disability also includes a person who is perceived to be disabled. That means if an employer perceives that COVID-19 has made an employee disabled or regards an employee as disabled because of COVID-19, that employee would fall under the definition of the protected class of disability, whether or not they actually are disabled by COVID-19. A reasonable accommodation is any change or adjustment to a job or work environment that permits a qualified applicant or employee with a disability to participate in the application process, perform the essential functions of the job, or enjoy benefits of employment. One thing to remember is that not all reasonable accommodations go to performing the job. An employee may need time off for treatment or to recuperate, or you may have an employee who needs an accommodation to access the break room or printed materials that you keep on a bulletin board. Other examples include dictation software, directions in writing, phone with volume controls, flexible work hours, telework, or leave. When a person with a disability makes a request for a reasonable accommodation, as an employer, you must provide a reasonable accommodation unless to do so would be an undue hardship. This is an affirmative obligation. When dealing with reasonable accommodations for disability, it's best to think of it as a process. So, what triggers that process? How do you know when you have to provide such an accommodation? The first thing that triggers that process is when a request for an accommodation is made. The second thing that could trigger the process is knowledge an employee has a disability that requires an accommodation to perform the essential functions of the job and is unable to put forth a request due to the disability. Two examples of when an employee is unable to put forth a request due to disability is if an employee is in an accident that results in the employee being in a comatose state, or when an employee experiences a cognitive disability that makes them unaware of their rights or obligations under the law. There was a case where an employer terminated an employee for no call, no showing after she fell off a horse and was in the hospital with a brain bleed. Since the employer was aware of the circumstances, the employer was obligated to provide an accommodation to the employee since she was unable to request one due to disability. There is no requirement for magic words. A person does not have to use the words disability or accommodation. The employee only needs to give you enough information to put you on notice that they need some type of modification at work due to a medical condition. Not only can the employee use plain English to make such a request, but a request can be very informal as well. Basically, if you have an employee that brings up a medical condition or impairment, expressly or implicitly, and then he or she talks about how this is impacting their work in some manner, your best bet is to consider this type of statement a request for accommodation. Unfortunately, a lot of employers tune out these types of conversations or requests, and it creates some trouble down the road. Employers should also take note that someone other than the employee can make a request, such as an advocate or a spouse. There are no time restrictions to asking for an accommodation either. An employee can request an accommodation upon being hired or at any time during employment. Additionally, applicants for a job position can request reasonable accommodations as well. Also, if an employer has a form for employees to fill out in order to request an accommodation, please remember that an employer cannot ignore an oral request that was made even if the employee does not follow through with turning in the initial form. The Bureau recently had a case where an employee informed his supervisor that he was experiencing what he called gut issues, and he kept calling out sick. He would check in with his supervisor quite frequently to call out or let her know when he was going to the doctor, but after 3 weeks he was fired for job abandonment. This case went cause because the employee's notice of a gut issue to the employer and his request for time off was sufficient to constitute a request for accommodation. The employer did not recognize it that way. So on the heels of that example, let's go over some more examples to explore what is and is not a request for accommodation. There is no way that I can finish these reports by Friday. No, this is not a request for accommodation. While the employee is making a statement regarding their ability to finish what may be an essential job function, there is nothing in the statement that connects the employee's inability to finish the reports with a medical condition. I've started a new medication and I'm not going to be able to come into work at 8 anymore. Yes, this is a request for an accommodation, assuming the employee is making this statement to a supervisor or someone in management. The employee's statement about a new medication implies that the employee has a medical condition necessitating medication. So the employee is implying that a medical condition is impacting his or her ability to arrive at work at 8 a.m. This type of statement is a request for an accommodation that might necessitate a modification to policy regarding what time the employee must arrive at work to be on time. I totally want that $769 chair that Mike has in his office. No, this is not a request for a reasonable accommodation for a disability. I'm sure everyone in the office would love to have Mike's expensive chair. While the statement is making a request, that request is not tied in any way to a medical condition or impairment. The new phones are not working with my hearing aid. Yes, this statement is a request for a reasonable accommodation. Again, assuming the statement is being made to a superior, the employee is putting the employer on notice that they have a hearing impairment necessitating a hearing aid and that impairment is impacting his or her ability to use a piece of office equipment. I'm super tired. Can I go home? No, this is not a request for reasonable accommodation. I'm sure a lot of people have requested time off because they are tired. However, an individual expressing he or she is tired does not suggest that individual experiences a medical condition or impairment. But remember, context is king. So for example, if you have an employee that you know has epilepsy and that employee experiences a seizure at work and right afterwards makes this statement to you, in that context, such a statement would be a request for accommodation for disability. So now that you know how to identify a request for accommodation, what do you do with such request? The answer is what's called the interactive process. Both the employer and employee who is requesting an accommodation have a duty to engage in the interactive process. Once you recognize a request for an accommodation, you should begin the interactive process as soon as possible. Having a good, clear policy that meets the needs of your business in these situations is going to be your best guide in how to engage in the interactive process. If you're looking for some policy ideas, you can see how the state's Human Resources Division handles reasonable accommodations online in the Montana Administrative Rules. It's ARM 2.21.41. The establishment and implementation of policies are imperative. However, remember that every interactive process you engage in as an employer will likely be different. These are case-by-case situations with varying complexity. Some interactive processes will be very easy with a simple accommodation identified and put into action rapidly. Others can take days and require multiple meetings and gathering of information to be reviewed in order to determine an effective accommodation. So keep that in mind. A question that often comes up is if attorneys need to get involved. The short answer is no. Perhaps if there is ongoing litigation, it could be helpful to consult your attorney, but generally you do not need to be represented to engage in the interactive process. However, it would be a good idea to document the process. Take really good notes, draft memos, and send emails of what's happening. When all is said and done, know who is going to do what when you're walking out the door after a meeting for an interactive process. The keys are to engage in the process in a timely manner and in good faith while maintaining positivity. Here are some important points to remember regarding the interactive process. The interactive process requires communication and good faith exploration of possible accommodations between employers and individual employees. The shared goal is to identify an accommodation that allows the employee to perform the job effectively. Both sides must communicate directly and exchange essential information. Neither side can delay or obstruct the process. When a party obstructs or delays the interactive process, that party is not acting in good faith. Remember, good faith is a requirement when engaging in the interactive process, not tepid faith and not passive-aggressive faith. So if you're a manager or supervisor with a request for disability accommodation in front of you, do your best to check your emotions and preconceptions about abilities and disabilities, and don't bury your head in the sand thinking the request will go away. Remember that you're always better off erring on the side of caution regarding identifying requests for accommodation, even if you have doubts about the disability or the request. Going through the interactive process is the employer's tool to allay those doubts and get the verification and understanding they need regarding the request. During the interactive process, an employer is entitled to reasonable documentation from the employee, documentation that establishes a person has a disability and the disability necessitates a reasonable accommodation. These are 5 basic steps you can follow to make sure you cover the necessaries when engaging in the interactive process. Some steps aren't applicable for some types of accommodations, like if an employee with cancer needs leave or an employee in a wheelchair needs equal access to a break room, but this is a general guide. And in general, the basic steps are: first, analyze the particular job. Second, consult the individual with a disability to ascertain the precise job-related limitations imposed by that individual's disability. Third, identify potential accommodations and assess the effectiveness. Fourth, implement the accommodation. And fifth, monitor the accommodation. Next, we are going to review each of these steps in a little more detail. When trying to determine an appropriate, reasonable accommodation for a disabled employee or assess an accommodation proposed by an employee with a disability, the first common sense approach under most circumstances will be to analyze the employee's job. This includes a review of the job description and identifying the essential functions of the job. Not only will this review help the parties to understand and identify potential accommodations better, but it is also important because an employer is not obligated to reallocate or remove essential job duties as an accommodation. An employer can choose to do so, but there is no legal obligation. Job restructuring includes the redistributing of marginal functions or an altering of when or how an essential or marginal job function is performed. If an employer offers a job restructuring as a reasonable accommodation that eliminates some marginal functions of a job, the employer may require the employee to take on other replacement marginal functions that they are capable of performing with their disability. Some of the factors in differentiating an essential function from a marginal function include the employer's judgment of which functions are essential, the amount of time spent on job performing the function, the consequences of the employee not performing the function, the terms of the collective bargaining agreements that may exist, the work experience of past employees in the job, and the current work experience of employees in similar jobs. The next step after analyzing the employee's job is to talk to the employee. An employer should engage in dialogue with the employee about the implications of his or her disability on the essential functions of the job. Since an employer is obligated to provide an effective accommodation, it behooves the employer to understand the barrier experienced by the employee at work due to disability. Some questions that may come up in this type of dialogue include, how does the disability affect job performance? Is the condition progressive, stable, or unpredictable? What specific job tasks, work environments, equipment, or policies are creating barriers to a successful job performance? And is there documentation to support the condition and need for accommodation? Let's quickly address the issue of evidence to support the employee's need for an accommodation. Employers often call the Bureau when they get a disability accommodation request, and one of their concerns is a doubt that the employee is even a person with a disability. If that's the case, that an impairment is not obvious, then the interactive process is your tool as an employer to verify the employee's status as a person with a disability and need for an accommodation. However, an employer is only entitled to reasonable documentation that establishes a person has a disability and the disability necessitates a reasonable accommodation. Requesting an accommodation does not give you the right as an employer to know someone's entire medical history. Instead, you must stay focused on figuring out whether someone has a condition or impairment that substantially limits a major life activity and how and why they need the accommodation to address this condition or impairment in order to perform an essential function or access benefits. If a person has more than one disability, an employer can only ask for information pertaining to the disability at issue in the accommodation request. An employer may require the documentation about the disability and functional limitations come from an appropriate medical provider. The appropriateness will depend on the disability and type of limitation, but can include doctors, psychiatrists, psychologists, nurses, physical therapists, occupational therapists, speech therapists, vocational rehab specialists, and licensed mental health professionals. An employer can ask an employee to sign a limited release to allow an employer to submit a list of specific questions to a medical professional addressing the existence of a disability, its functional limitations, and the need for reasonable accommodation. Also, be mindful of the time and cost associated with obtaining medical information. Do not ask someone for medical verification if they've provided sufficient medical information already, or if the impairment is obvious. If you're concerned about the veracity or viability of the medical information provided, an employer can require an employee to visit a healthcare professional of its choosing and at its own cost, but tread lightly. Beware of the battle of the medical experts. Keep all medical inquiries job-related and consistent with business necessity. Ultimately, if an employee refuses to provide documentation and the disability is not obvious, the employee is not participating in good faith and is not entitled to a reasonable accommodation. On the other hand, if an employer has information that a reasonable person would believe is sufficient to document the disability and need for an accommodation, and the employer refuses to move forward on the request, the employer could be liable for failure to provide a reasonable accommodation. Here at the Bureau, we have seen cases where charging parties go to their employer with specific accommodation requests. They feel they've already identified what accommodation would assist them in the workplace. We also have had cases where a charging party is more uncertain but knows they are experiencing a work issue due to disability, but they don't know right offhand how to solve it. In either situation, having a conversation with an employee in the context of the interactive process will hopefully give both parties an opportunity to brainstorm all possible ideas that could potentially overcome the workplace barrier. Remember your shared goal of identifying an accommodation that allows the employee to perform the job effectively and be prepared to bring ideas to the table. Some examples of possible accommodations include more frequent breaks from work, scheduling changes, leave for medical appointments or to recuperate, amplified telephones, standing desks, non-fluorescent lighting, and written rather than verbal instructions. Let's take a moment more to talk about leave as an accommodation because the Bureau has seen cases where some employers do not realize that leave can be an accommodation for a disability. In certain contexts, it seems intuitive. For example, if someone has cancer and needs extended leave to get treatment. But what if you have an employee who, like in the earlier example, just keeps calling out sick day after day, telling you they have something as uncertain as gut issues, and is going to the doctor for it periodically? As mentioned previously, in that scenario, the Bureau took the employee's notice to the employer of the medical condition and calling out sick as a request for an accommodation, while the employer, in the moment it was happening, was just looking at it as an employee using sick time and refusing to come back to work. So in light of this example, just remember that in the face of uncertainty, you are almost always going to be better off in engaging in the interactive process with an employee. Engaging in that process will allow you as an employer the opportunity to get additional information, even medical documentation, that you need to make an appropriate and informed decision regarding the situation at hand. In this particular example, the employer not only denied knowing that the employee had medical issues, it also acknowledged that it did not know that leave was an option as an accommodation for a disability. Now keep in mind that if you allow an employee leave as reasonable accommodation, you cannot penalize the employee for taking leave, such as it affecting performance reviews, raises, or discipline after the employee incurs a certain number of absences. Also, an employer should allow an employee taking leave as an accommodation to use accrued leave time, and then if that is exhausted, the employee can begin taking unpaid leave. And if you reach a roadblock or need assistance in identifying options for accommodations, reach out to Jan for help. As a last resort, when an employee cannot perform the essential functions of his or her current position with or without reasonable accommodation, an employer must look at whether or not the employee can be reassigned to another position. The position must be vacant at the time the accommodations are being considered or vacant within a reasonable time, which is determined on a case-by-case basis. Also, the employee must be qualified for the new position. An employer does not have to throw an accountant into an attorney position, for example. So while the employee being considered for reassignment must be able to satisfy the required skills, education, and experience needed for the new position, and be able to perform the essential functions of the job with or without a reasonable accommodation, the employee does not have to be the best or most qualified person for the position in order to get the position as a reassignment. With that being said, an employer does not have to train up the employee for the position to make them qualified either. But the employee is entitled to the same type of training for the position that any other successful candidate would have received. The reassignment must be to a vacant position that is equivalent in pay, status, and benefits to the previous position. If there is no equivalent position vacant, the employer must reassign the employee to a vacant lower level position for which he or she is qualified. If there is more than one vacancy available that the employee is qualified for, the employer must place the employee in the position that is the closest to the employee's current position in terms of pay, status, and benefits. Reassignment does not include a position that would be considered a promotion. So through the interactive process, you have identified and agreed upon with the employee what accommodation will effectively help the employee overcome the workplace barrier experienced due to disability. Now is the time for action. In a timely manner, the chosen accommodation should be implemented and put into place. Remember that an employer is not obligated to provide the accommodation that the employee requested or wants. The employer is only required to provide an effective accommodation. Of course, an employer should consider the employee's preference. However, if there is more than one accommodation that would be effective, the employer can choose the least burdensome or most cost-effective choice. The EEOC guidance on the subject states that if more than one accommodation is effective, the preference of the individual with the disability should be given primary consideration. However, the employer providing the accommodation has the ultimate discretion to choose between effective accommodations. Once the agreed-upon accommodation is implemented, the work is not over. An employer's duty to provide reasonable accommodation is an ongoing one. Best practice would be for an employer to be proactive, setting up some type of system for monitoring or checking in with the employee in order to evaluate the effectiveness of the accommodation. Remember that an employee's disability can change over time, necessitating a change in accommodation. If an employer discovers that an accommodation is not working out, or the employee informs the employer that the accommodation is ineffective, the requirement to engage in the interactive process resumes. Work together again to identify a new effective accommodation. Also, an employee may need more than one accommodation for a disability. There is no limit to the number of accommodations. However, an employee is only entitled to those accommodations that are necessitated by a disability and that will provide an equal employment opportunity. If you're looking for the ultimate defense to a failure to accommodate complaint, all you have to be able to show is that you participated in good faith in the interactive process. From that engagement, you will either have provided an effective and reasonable accommodation or determined that there was no effective reasonable accommodation possible. Again, the effective accommodation provided does not have to be the one requested by the employee. If you get into an interactive process and the employee is not participating or providing necessary and relevant information, you can put the interactive process on hold until you get that information. If that is the case, make sure you document what it is you're doing and why, including informing the employee so that he or she has an opportunity to provide the necessary and reasonable documentation requested. Finally, employers are never required to provide accommodations that present an undue burden or hardship. It's called a reasonable accommodation, not an unreasonable accommodation. So if something is unduly burdensome or fundamentally alters the way you do business, you do not have to provide it. The factors to consider when evaluating whether or not an accommodation is an undue hardship include the nature and cost of the accommodation, and the overall financial resources of the location making the accommodation, including the number of persons employed at the location and the effect on expenses at the location. If the business has multiple locations and is part of a larger entity, the employer must also assess the overall financial resources of the company and not just the location at issue. The type of operation of the employer and the impact the accommodation would have on operations is also a consideration. The Americans with Disabilities Act legislative history shows that Congress wanted employers to consider all possible sources of outside funding when assessing whether a particular accommodation would be too costly. Also, undue hardship is determined based on the net cost to the employer, so the availability of outside funding like state rehabilitation agencies or eligibility for tax credits to offset the cost of the accommodation should be taken into account as well. Furthermore, an employer should ask the employee with a disability if they are willing to pay for a portion of the accommodation, if a portion of the cost is too burdensome to the employer. The employee should be given the opportunity to pay the difference in those circumstances. When an employer is considering whether an accommodation poses an undue hardship, it should calculate the costs and preserve the information used in order to reach a determination. If an accommodation would be unduly disruptive to coworkers' ability to work, such a situation could constitute an undue hardship. As an example, the Bureau had a case with a charging party with a mental impairment who requested that any time management needed to speak with her at work, that a coworker attend the conversation. Since there were only 4 coworkers, having to pull someone away from their work at any moment's notice would have been an undue hardship. However, the possible lowering of coworkers' morale cannot be an undue hardship. For example, if an accommodation includes the reallocation of marginal functions to a coworker, the fact that the coworker is unhappy about the extra work but is still able to perform their own essential functions effectively is not enough to constitute a disruption to operations and undue hardship. Remember, it may be easy to accommodate your stellar employees. It can present a challenge to accommodate a more difficult employee. And yet, your legal obligations are the exact same. Regarding stellar versus challenging employees, be aware that performance is always on the table. A request for a reasonable accommodation does not require an employer to tolerate or excuse poor performance, withhold disciplinary action warranted by poor performance, raise a performance rating, or alter a performance evaluation that does not reflect the employee's actual performance. It is not reasonable to lower or change performance standards at work, assuming the performance standards are measuring the essential functions of the job and not marginal functions. An employer is never required to excuse past misconduct, even if it is the result of the individual's disability. If an employee with a disability violates a conduct rule or policy, the employer can still discipline the employee for engaging in the misconduct if the employer would impose the same discipline on an employee without a disability. So what should you do if you're in the middle of issuing an employee discipline for being tardy repeatedly and the employee discloses that the reason he is tardy is because he's taking new medication with the side effect of making him extremely groggy in the morning? If an employee asks for accommodation in response to a reprimand, counseling, or a poor performance evaluation, the employer can finish the discussion regarding the performance issues and issue the discipline. The employer can also use that time as an opportunity to begin the interactive process by discussing how the disability is impacting the performance and what accommodations the employee sees as necessary. If you choose not to engage in the interactive process at that time, don't forget to set up a time, in a reasonable time frame, to revisit that topic and begin the interactive process. Remember to take into account the severity of the barrier the employee is experiencing when determining what is a reasonable time frame to get the interactive process started and an effective accommodation in place. There have been accommodations cases at the Bureau where the cause finding hinged on the employer's delay in engaging in the interactive process or implementing an accommodation. Remember, not only is delaying a sign of bad faith, but also justice delayed can be justice denied. Because of confidentiality issues under disability discrimination laws, an employer must be careful with the types of questions it asks an employee regarding disability. So an examination of permissible questions when dealing with performance issues is necessary. If an employer knows or has reason to know that an employee is experiencing workplace problems because of a medical condition, and the employer knows that the condition prevents the employee from requesting an accommodation, the employer has a duty to ask the employee if he or she needs an accommodation. As mentioned earlier, circumstances that would impose this obligation on the employer include if an employer knows that an employee falls into a coma, or if the employee experiences a cognitive disability that makes them unaware of their rights to ask for an accommodation. On the other hand, the employer is allowed to ask, but is not duty-bound to ask if an accommodation is needed if the employer knows an employee has a disability that may necessitate an accommodation. For example, if an employer knows that an employee experiences major depression and reasonably believes that the disability is impacting the employee's work product, the employer can inquire with the employee if they need an accommodation. As another example, if an employer is scheduling an off-site meeting and has concerns whether the meeting location will be accessible for his employee in a wheelchair, the employer can ask the employee about possible accommodations for the meeting. It can all get rather confusing trying to determine when you can and cannot ask your employees about disabilities or impairments, but know this: you can always talk to your employees about how they are doing generally. If you see someone that's having a rough go, you don't really need to talk about impairments or disabilities. You can talk about what he or she needs to be successful. That type of conversation may well trigger a broader conversation, a conversation about reasonable accommodations, or maybe the person has no clue that their performance has deteriorated. So again, you can always ask your employees if they need anything to be successful. So in conclusion, here are some pro tips for employers that are applicable to any type of anti-discrimination law in the area of employment. First and foremost, having clear and effective policies is paramount. The difference between a good employer and a bad employer is not that good employers do not have discrimination complaints lodged against them, but rather, good employers have a process in place and will investigate and deal promptly, thoroughly, and fairly with complaints. Having quality anti-discrimination policies that specifically address discrimination based on all protected classes, reasonable accommodations, maternity leave, harassment, and retaliation is key. Post your policies. Make sure you get them in front of your management team and employees periodically to do reviews and make them accessible. Train your management and employees on these policies. Make sure your employees understand that discrimination is taken seriously and that their actions expose your business. In order to make sure your employees understand their employer takes discrimination seriously, good behavior should be modeled from the top down. Some written policies outline a procedure to inform employees the different ways that complaints of discrimination and retaliation can be made. If your business does not have that in its written policy, make sure to establish a complaint procedure. Making sure that complaints are addressed properly is important as well. Employers must promptly investigate complaints and engage in the interactive process when necessary. Employers should be aware of retaliation issues and implement policies and procedures to ensure no retaliation takes place after an employee requests an accommodation, complains of discrimination, or participates in an investigation into discrimination. And last but certainly not least is document and understand your decisions. Remember, this may be the evidence you need to defend against a discrimination or retaliation complaint. Would you like to learn more about the Montana Human Rights Bureau or the laws that the Bureau enforces? Visit our website at www.montanadiscrimination.com or give us a call toll-free at 1-800-542-0807 or locally 406-444-2884.